So thank you. Good morning, ladies and gentlemen, dear colleagues from the project. First of all, I would like to express my sincere thanks to the Central European Academy for inviting me to take part in today's conference, and a big thank you, Professor Marcin Bielec, to invite me to take part in your project. In my presentation, as you can see, I put two questions. How much freedom does local government have, and how much does it have compared to central government? However, I would like to add one more question, maybe even more important, to put the issue into perspective. So, to what extent does the legal framework governing the autonomy of the government provide it with scope for protection in the event of a crisis of the rule of law caused by the central government? For it is obvious that local government is a separate unit from the central administration. Poland's political transformation that took place more than 30 years ago aimed to rebuild local democracy and create strong, effectively autonomous local government units capable of independently performing public tasks with their own assets and legal liability. It is pointed out that the framers of the constitutional and legislator of the 90s envisage a strong component of local authority, autonomy, counterbalancing central authority and enabling the decentralization of public activities. So I would like to analyze 5 areas: constitutional status, scope of own task, organizational autonomy, financial autonomy, legislative autonomy, and first to begin with the constitutional status of the local government and the nature of their self-government as defined therein. Local government in Poland is a constitutionally guaranteed form of decentralization of public administration, possessing legal personality and the capacity to perform public tasks independently. Pursuant to Article 16.2 of the Constitution, local government performs public tasks in its own name and its own responsibility, which means that the legislator has granted it a separate title to act, not subordinate to central government administration, based on the dualism of public administration. The Constitution further provides that the self-government's independence is the subject of judicial protection, which in legal doctrine is understood as a guarantee safeguarding of the constitutional position against excessive interference by the central government. I will discuss this more deep a little bit later in my presentation. So the existence of local government is based on the principle of subsidiarity. Subsidiarity provides a framework for competence sharing between authorities on various levels of administrative territorial division, with the intention of creating synergies from the varied actors' inputs, expertise and resources. Assuming the principle of subsidiarity as a guiding principle for organizing the state leads to a reduction of central government prerogatives, decentralizing and passing them on to the sub-national government. It would be emphasized, however, that the local government's autonomy, despite constitutional guarantees, of course, is not absolute. Local authorities operate on the basis of and within the limits of the law, which is the manifestation of the general principle of legality of administration. This means that any form of autonomy is autonomy within the law rather than legislative autonomy in the sense of complete freedom. Local government autonomy, therefore, stems directly from constitutional provisions, but its scope is defined in more detail by the legislature, which becomes a point of tension between decentralization and centralist tendencies and may be exploited in the event of a crisis of rule of law. The scope of all tasks as a measure of local government autonomy. Now a few words of the local government's own tasks, which constitute a key determinant of its self-reliance. Systemic laws, namely the Act of Municipal, Country and Provincial Self-Government, define a catalogue of their own tasks, covering typical local matters such as primary education, local public transport, social policy, spatial planning, and many others. In legal doctrine, this scope is regarded as an area of natural autonomy, within which local government units have priority of action and decision-making autonomy. However, academic research points to significant limitation of this autonomy, arising from both the practice of applying the law and from administrative court case law. It is strictly required that every action taken by the municipality in the sphere of public authority must have a clear positive basis in law. Consequently, if municipality takes actions to go beyond its enumerated task or takes actions within the scope of its task, but in a form not specified by law, its acts are annulled as lacking of legal basis. It is confirmed, for example, by a ruling of the court in Lupin. The subject of the court proceedings was a resolution of the municipal council concerning the adoption of regulations for awarding the distinguished service to the municipality statuette. The court agreed with the provincial governor's supervisory decision and ruled that, since there is no legal provision providing a basis for the municipality to adopt such a resolution, the municipality did adopt it, instead broke the law. In the second judgment, shown on a slide, the court in Olsztyn ruled that the municipality, by adopting the municipal program for supporting the education of talented children and young people in the form of the local law, had infringed the law because it had not preserved the legal form. It is worth noting that the Educational System Act allows a municipality to adopt an act on this matter, but the legal basis for adopting the program existed, but the act didn't stipulate that it had to be a local law. This means that the municipality couldn't have adopted this resolution in a form of local law. From the perspective of administrative law doctrine, this means that the scope of local government's freedom is essentially a function of how the law is interpreted. For a more functional interpretation is permitted, autonomy can be expanded. If the interpretation remains extremely legalistic and literal, autonomy is reduced. Furthermore, it is closely linked to the case of administrative courts, and the consistency of that case law varies. The following example concerning environmental matters illustrates this very well. In past, in several rulings, the courts initially took the view that it was not permissible to include restrictions on the type of heating system in newly constructed building within local spatial development plans. These kind of plans are resolutions and are adopted by local authorities. And later adopted a different line of jurisprudence, holding that it was in fact permissible. This latter line of jurisprudence remains in force to this day. The consistency of case law does not strengthen the legal positions of local government. I shall now move on to the third point, organizational autonomy. The organizational autonomy of local government lies in its ability to shape its own internal structure, establish organizational units, regulate the internal organization of the council, and determine the operating principles of the executive body. This is one of the areas in which local government autonomy is most fully expressed in which, in accordance with the theory of decentralization, the principle of subsidiarity and the freedom to choose organizational measures should prevail. In discussing organizational autonomy, I want to draw attention to two aspects. The first concerns the need to agree the statutes of large cities with the Prime Minister. This is undoubtedly a greater level of interference than in the case of the other municipalities, but it must nevertheless be remembered that this kind of statutes of every municipality, large or small, doesn't matter, are subject to the supervision of the provincial governor. The second issue concerns the powers of the Council of Ministers regarding the 3 points shown on the slides. The Council of Ministers establishes, merges, divides, abolishes municipalities, and determines their boundaries, grants municipal status, and so on. Available data show that in 2025, out of 28 applications governing various changes of municipalities, such as the establishment of the new municipality, boundary changes, or the granting municipal rights, as many as 9 didn't receive a positive recommendation of Council of Ministers. Although the criteria for changes to municipalities are laid down by law, they are mainly of a general nature, which allows for broad interpretation by the Council of Ministers. In practice, it is often argued that decision on the creation or alteration of municipal boundaries depend not on a substantive grounds, but on political will. It is difficult to view cases such as creation of the two municipalities of Szczawa and Grabówka in any other light. In July 2015, so almost 11 years ago, the Council of Ministers approved the creation of these municipalities. And more or less half years later, the Council of Ministers reversed its decision. It was 2 days before the changes were due to come into force. The municipalities were eventually established, but only 10 years later, which means more or less 1 year ago. Decision by the Council of Ministers to establish new municipalities or alter their boundaries are a source of constant conflict between local authorities and their residents. The fundamental case of such conflicts is the lack of judicial review of the Council of Ministers decision. Very rare example that we don't have in our law such relation. Now I would like to move on to next issue, the fourth one, financial flexibility. The next criterion concerns financial flexibility, autonomy, which is often regarded as the foundation of any entity's genuine independence. Without sufficient own revenue, local authorities are unable to carry out public tasks independently. However, in practice, the full autonomy of local authorities is more a theoretical concept, given that the vertical and horizontal inequities in public finances or the need for the state to pursue a stabilization policy. I want to highlight 2 areas in which central government can influence a municipality's finances. The first is the share of own revenue in total revenue, considered a key indicator of local authorities' financial autonomy, illustrating that proportion of the budget comes from the local sources rather than from grants and subsidies. This share has been falling over the years. In constant, the share of special purpose subsidies in the revenue structure of local authorities is increasing year on year. This allows the central government to influence the direction of local government activities because rather than increasing the potential to collect a larger amount of tax as own revenue, the government implements and proposes to local authorities a large number of various aid programs under which additional funds, grants and subsidies can be obtained for a specially defined purpose, but purpose defined by the central administration, not by the local authorities. The share of municipalities' own revenue in the total revenue fell from 74.5% in 1991 to just 48.8% in 2020, which means a significant increase in local authorities' dependence on central government transfers, particularly targeted subsidies and grants. In such situation, local government bodies tailor their investment plans to the availability of funding for specific projects. The phenomena of the state influencing the autonomy of local government bodies by deploying various financial instruments is in most cases viewed negatively. Some legal scholars refer to this as an instrument of pressure, especially referring to subsidies, grants from European funds, and describe the process as financial recentralization. And the second area relates to the principle of adequacy, which is understood as the obligation to ensure an appropriate level of revenue in relation to the task imposed. It stems from the provisions of the Polish Constitution and the European Charter of Local Self-Government, and it is regarded as a fundamental European standard with regard to the functioning of local government. In accordance with this principle, the revenue of local government units should be set at a level sufficient to finance the task for which these units were responsible under statutory and constitutional law. This is one of the most conflicting areas. Disputes frequently arise between representatives of local government bodies and representatives of the central government, in which the local governments demands that the government allocate more funds for the implementation of the task assigned to them, whilst the government, of course, refuses. It sometimes happens that the Constitutional Tribunal is called upon to resolve the dispute to which local authorities lodge complaints. And what happens? In some judgments, the tribunal emphasized that the legislature may not make changes to the task and powers of local government bodies without making corresponding changes to the distribution of public revenue. Furthermore, in the tribunal's view, any reduction of revenue may only take place by way of legislation and subject to strict scrutiny of the legislative process. In others, it adopts a position which, however, it is difficult to describe as a pro-local government. In one of them, the tribunal clearly stated that the principle of the financial autonomy of local government cannot be treated as absolute. In the tribunal's view, as long as the legislature does not drastically infringe upon every essence of the municipality's financial autonomy, it enjoys far-reaching discretion in determining both the source of municipalities' own revenue and the level of such revenue. Furthermore, the Article 167.1 of the Constitution cannot be interpreted as a basis for imposing an obligation to guarantee local government units a specific level of revenue in isolation from the financial situation of the state as a whole. The result is a restriction on the local government's ability to carry out tasks independently, and in particular, the loss of the ability to respond to local needs quickly and flexibility. And now I'd like to move on to the next issue, self-government entities legislation, autonomy, freedom. But maybe in that case, the freedom, it is the word, it must be explained very carefully. Self-government entities are empowered to enact local legislation, general and abstract legal norms applicable within their territory. This is one of the strongest forms of expression of local public law autonomy. Local laws includes implementing acts and statutes, planning acts, and regulatory acts, and many others. Nevertheless, the local government's legislative freedom is strictly limited on three levels. First of all, the basis of competence. Self-government units may issue an act only on the basis of an explicit statutory authorization. Legality control. Acts may be repealed by the provisional government of administrative courts. The scope of permissible regulation. Self-governing authorities may not create substantive legal norms without statutory delegation. In practice, this means that the normative autonomy of self-governing local authorities is subject to the principle of legality and the supervision of central government. In light of these factors, local authorities are entities with very limited capacity to create local law and their legislative freedom, though constitutionally recognized, is of purely derivative nature. Now let's move on to the next slide. Administrative court judgment and, in general, judicial protection. The autonomy of local government is autonomy within the bounds of the law, combined with supervision and control in accordance with the principles set out in the constitutional and constitutional law. The two main supervisory bodies are the provincial governor and the regional audit chamber. The scope of the regional chamber's supervision is limited to financial matters. In the other matters, supervision is exercised by the provincial governor. And I would like to add, by way of clarification, that jurisdiction over a few matters is reserved for the Prime Minister. Local government bodies enjoy judicial protection against unauthorized interference by supervisory bodies. But available data show that in 2024, local government bodies lodged only 216 complaints against supervisory decisions with the administrative courts. During this period, the court examined 209 cases, of which it upheld the complaints in 63 cases and dismissed them in 130. However, complaints, namely 188, were lodged 1 year before. So in 2023, of the 201 cases dealt with during this period, the court upheld 16 complaints and dismissed 125. The data showed that the scale of complaints lodged against supervisory decisions is truly small. Annually, in every province, the number of resolutions subject to supervision runs into tens of thousands, which means that complaints against supervisory decisions are used only in exceptional matters. And to sum up, let's go to the conclusion. Key findings. The formal autonomy of local government bodies is strong, but its actual scope is narrowing as a result of legislative actions and judicial practice. The own task of local government bodies are subject to a strict legalistic interpretation, which limits the scope for action not provided for in the Act. Organizational freedom. Local government regulations and statutes are subject to the supervision of the provincial governor in accordance with general principles. Furthermore, any restructuring within municipalities requires the consent of the Council of Ministers. And financial autonomy. Crucial to self-governance is significantly weak, along a decline in the share of their own revenue in the overall local government budgets. The legislative freedom of local government units is severely restricted to legally oversight and the restrictive approach of the Supreme Administrative Court. In times of crisis, the government may broaden the interpretation of legality to justify stronger oversight. The judiciary remains the strongest means of protection local government against the actions of the central administration, both the ordinary courts, but above all, the administrative courts and the constitutional tribunal, provided that the interpretation of the law favors local government, which, as even the examples cited in the presentation show, is not always the case. In light of the above, it can be concluded that although the Polish model of local government is structurally decentralized, the actual scope of decision-making by local government units can be easily restricted. And thank you for your attention.